Ladies and gentlemen, the International Court of Justice is now in session. Before we begin, please allow me to introduce myself. My name is Garam Reza Effendi, as a registrar of the morning case. To provide some context, I will briefly describe the merits of the case. The dispute between Gabon and Equatorial Guinea began in the 1970s, arising from conflicting claims of Benin Island and the newly isolated Cocotel and Conga, located in the recent rich Gulf of Guinea. The disagreement intensified as both countries sought control of the surrounding maritime area, believed to contain valuable oil and gas reserves, leading to a prolonged territorial and maritime boundary conflict. Please remain standing off the chair. Please be seated. I will invite the President of the Court, His President Judge Leonardo, to open today's hearing.
Thank you, Registrar. The court convenes today to hear an oral argument in the case of Gabon versus Equatorial Guinea. We remind the parties that the hearing reported with opening statements, witness examination, question from the bench, and closing remarks, followed by the delivery of the court decision at the end of the session. The court now is in session. Will the parties please confirm the presence?
Yes, Your Honor.
Before hearing the opening statement from the parties, I invite all just to introduce themselves. Just our company invite to introduce themselves.
My name is Raditya Wardana, as the second judge of this international court for the dispute between Gabon and Equatorial Guinea.
My name is Hassan Hendrika, as the third judge of this international court of the dispute between Gabon and Equatorial Guinea. My name is Zara Anggita, as the fourth judge of this international court for the dispute between Gabon and Equatorial Guinea.
My name is Faris Ramadan, as the fifth judge of this international court for the dispute between Gabon and Equatorial Guinea.
My name is Ahmad Aulia Cesarianto, as the chief judge of this international court for the dispute between Gabon and Equatorial Guinea.
My name is Deva Kavya, as the seventh judge of this international court for the dispute between Gabon and Equatorial Guinea.
My name is Riana Kalafif, as the eighth judge of this international court for the dispute between Gabon and Equatorial Guinea.
My name is Iskandar Rafedi Ramdan, as the ninth judge of this international court for the dispute between Gabon and Equatorial Guinea.
My name is Rifai Sadayawan, as the 10th judge of this international court for the dispute between Gabon and Equatorial Guinea.
My name is Andrew Vaisuyana, as the 11th judge of this international court for the dispute between Gabon and Equatorial Guinea.
My name is Ademi Tasman Sendiri, as the 12th judge of this international court for the dispute between Gabon and Equatorial Guinea.
My name is Muhammad Fozan Arjuna, as the 13th judge for international court for dispute between Gabon and Equatorial Guinea.
My name is Rasul Muhammad, as the 14th judge of this international court for
the dispute between Gabon and Equatorial Guinea.
My name is Sidang, the Section Judge of this International Court for the dispute between Gabon and Equatorial Guinea.
My name is Andrew Prasetyo, as the 17th Judge of this International Court for the dispute between Gabon and Equatorial Guinea.
Next, to the Gabon delegation, please introduce yourself.
Good morning, Your Honor and member of the judge. My name is Anissa Aulia, and together with my friend Gabriel Yafin and Surya Rega, we are here as a delegation in this case, and we will be representing our country, Gabon.
Thank you. The court will now hear the opening arguments of the plaintiff, Gabon. Counsel for Gabon, you may proceed.
Good morning, my name is Juliana, together with my partner, Juliana Domenico and Esonder. We are here as a delegation in this case and we will be representing our country, Equatorial Guinea.
The court did not hear the opening argument of the plaintiff, Gabon. Counsel for Gabon, you may proceed.
Yes, Your Honor, members of the court, Gabon appears before you today to reaffirm its claim of sovereignty over the islands of Benin, Cogatir, and Tonga. Our position is grounded in the historical title, Peaceful Administration and the intention expressed in colonial agreements that recognize this island as the part of Gabon territorial domain. We submit that the 1900s Franco-Spanish Treaty properly place the island within the maritime sphere historically administrated from Libreville. Gabon exercised routine administrative acts for decades, patrols, licensing, and naval presence without protest from Equatorial Guinea. We therefore ask this court to declare these islands under Gabonese sovereignty.
Your Honor, the plaintiff emphasizes that effective occupation effectivities must be interpreted in light of regional practices. For many years, Gabon maintained practical control in areas adjacent to the island, especially in maritime safety operation and resource supervision. Equatorial Guinea tends to rely heavily to technical interpretation of colonial documents. Yet Gabon conduct reflects actual state authority on the ground. We will demonstrate that Gabon behavior satisfies the legal threshold for activities in small and uninhabited islands.
Your Honor, the applicant will call two witnesses who will testify regarding Gabon's long-standing maritime operation in the area. Their testimonies will confirm that Gabon acts continuously and peacefully, consistent with sovereign authority. We trust the court will recognize that Gabon's historical involvement carries decisive legal weight.
Thank you, most for the plaintiff. The court now invites the defense Equatorial Guinea to present in opening arguments.
Your Honor, members of the court, Equatorial Guinea submit that sovereignty over Benin, Cogatir, and Conga is clearly established under the 900 and 901 Franco-Spanish treaties. These treaties allocated the islands unilaterally to the Spanish colonial administration, was territorial successor in Equatorial Guinea. Gabon's claim rests on assumption of proximity, not law.
Your Honor, Gabon did not exercise its full, continuous, nor public authority over the islands. Their islands presence is minimal and unsupported by documentary evidence.
process official maps, border recruitment, and diplomatic records demonstrating strength and later apparently gaining administration.
Your Honor, the resolution mentioned the 74 bilateral agreement between France and Equatorial Guinea further reinforces the information that the island lies within Equatorial Guinea domain. The applicant cannot reinterpret colonial boundaries simply because maritime resources have become valuable in modern times.
The respondents recall to witnesses who will testify regarding state patrols, administrative acts, and documentary evidence that consistently reflects Equatorial Guinea's authority. We ask this court to dismiss Gabon's claims either.
Thank you. We now proceed to witness examination. Plaintiff may call his first witness.
Please introduce yourself.
My name is Jessica Laurencia Shiraan as plaintiff witness.
Okay. Please be seated. The assembly declare that the testimony you shall give before this court shall be determined.
Yes, I do.
Mrs. Jessica, could you describe your experience in Gabonese maritime operations near the disputed island?
Yes, patrols were conducted routinely and without interruption. Our vessels moving in the area and no authority from Equatorial Guinea ever approached or challenged us.
In your observation, did Gabon exercise effective presence in the maritime area?
Yes, absolutely. The operations were organized, continuous, and hourly conducted.
Mrs. Jessica, you said the patrols based here on the island, but did you ever learn from the training or maintenance structure there?
No, we did not land. Our operations were manual.
So, your testimony confirms that Gabon exercise activity only in nearby waters, not on the island themselves.
Of course, yes. Our activities were in surrounding waters.
Thank you. No further question. Thank you, Mr. Jessica. You can back to your seat. The plaintiff may call his second witness.
Please introduce yourself.
My name is Tutsu Utamandita Karyaman as a plaintiff witness.
Please be seated. The assembly declare that the testimony you shall give before this court shall be determined.
Yes, I do.
Mr. Sora, could you explain your role in the Gabon's maritime environmental monitoring project?
I was a part of research in documenting marine biodiversity along the coast of the Gabon. Our surveys extended into the water near the disputed island.
Did your research activities receive authorization from Gabonese authorities?
Yes, all our missions were authorized and supervised by Gabonese agencies.
Did you encounter any questions or objection from Equatorial Guinea?
None whatsoever. Our team operated without interference for years.
Mr. Lucho, were any of your recent activities conducted directly on the island themselves? Yes or no?
No, our work focused on surrounding water.
So, can confirm about Gabon exercise administrative control over the land territory of the island.
That is correct. I can only speak for maritime area.
Thank you, Miss. No further questions.
Thank you, Mr. Solo. Now back to your seat. plaintiff will not examine his complaint. We now proceed with the defense witness. The court invites the defense to call its court witness.
Thank you, Your Honor. The defendant calls Mr. William Rahman. Please introduce yourself.
Good morning, everyone. My name is Bian Rahmat and I'm here as a defense witness.
Okay, please be seated. Do you solemnly declare that the testimony you shall give before this court shall be determined?
Yes, I do. Mr. Rahman, please describe your involvement with state patrol activities conducted by Equatorial Guinea around the disputed island. So I serve as part of Equatorial Guinea's Maritime Safety Division. Our patrol units regularly monitor the areas surrounding Miami, Cocodile, and Conga. We document existing roads, verified vessel registrations, and conducted periodic visits to the island. Did Equatorial Guinea ever conduct landing or inspection on this island? Yes, there were several official visits by our maritime officers. We observed no presence or objection from the bond during this operation. In your experience, did Equatorial Guinea's activities reflect sovereign authority? Yes, the state merely exercised administrative and operational control.
Mr. Ahmad, you mentioned inspection. Were this inspection documented formally in written reports?
Yes, the reports are internal and not publicly accessible.
So the court cannot verify them independently?
No, without verification. That is correct.
Did any of your inspection involve non-constructor, installation, or permanent reasons?
No, our presence was temporary during routine operations.
Thank you. No further questions.
Thank you, Mr. Rahman. You can back to your seat. And then we may call you next witness.
Thank you, Your Honor. The defendant calls Mrs. Elsa Almiana. Please introduce yourself.
My name is Elsa Almiana as a defense witness.
Okay, please be seated. Do you solemnly declare that the testimony you shall give before this court shall be determined?
Yes,
Ms. Williana, could you explain your work involving historical and administrative documents related to the island?
I reviewed Spanish colonial archives and administrative maps. This document consistently placed the islands under the territorial authority of Spain, whose successor is Equatorial Guinea.
Did the document show any recognition of Gabonese sovereignty?
No. The treaties of 1990 and 1901 clearly assigned those islands to the Spanish administration.
Your assessment. Do these documents support Equatorial Guinea claims today?
Yes, they provide a continuous legal basis for our sovereignty.
Ms. Aula, your document you mentioned were reported exclusively by Spanish authorities.
Yes, they were colonial records from Spain.
So they don't include any colonial verifications of actual presence in Equatorial Guinea.
No, they are historical documents.
Would you agree that historical document alone cannot prove modern international control?
They establish the legal foundation that additional evidence is also relevant.
Thank you, Mr. Almiana. Get back to your seat. We will now proceed with question from the bench. Just my voice. We question directly to the parties. We ask that the parties respond clearly. Proceed.
To govern, Counsel for the Plaintiff, can you clarify whether government ever established any physical installation on the island?
Your Honor, Gabon did not establish permanent installation on the islands, primarily because they are small, uninhabited, and have historically served only as maritime reference points. Our activities were mainly conducted through coastal patrols and traditional fishing routes. While non-physical structures were built, Gabon argues that effective presence at sea in context of uninhabited island constitute a relevant demonstration of authority.
To Equatorial Guinea. Did Equatorial Guinea ever maintain a permanent administrative presence on the island?
Your Honor, although the permanent installations were constructed due to the island's uninhabited nature, Equatorial Guinea carried out consistent administrative oversight through periodic inspection inherited from Spain. This includes maritime patrols, navigational monitoring, and the inclusion of the islands within colonial and post-colonial administrative mechanisms. Such action reflect continuous authority given without permanent habitation.
Together, does the plaintiff consider maritime activity alone sufficient to demonstrate sovereignty?
Thank you, Your Honor, and the member of the jury. We do not argue that maritime activity alone is always sufficient. However, in the specific case of uninhabited maritime features, long-standing usage, patrol, and recognition by local communities from important component of effective control, combined with historical understanding of regional spheres. These activities support Gabon's assertions of sovereignty.
And to Jimmy, are the colonial documents you rely on supported by post-independence acts?
Yes, Your Honor. After independence, Equatorial Guinea maintained and continues administrative solicitation, including hard-on regulation that lists the island within our jurisdiction. Our Navy also upheld regular patrol routes consistent with historical prospects. This continuity demonstrates as maintained sovereign fatal over time.
To Gabon, why did Gabon not rise for one diplomatic protest here?
Your Honor, Gabon did not initially protest because it understood the island to fall naturally within its maritime basin area on traditional usage and proximity. The absence of immediate protest reflects a belief that the status of the island was not in dispute until later development arose. Gabon acted when it became clear the respondent sought to formalize a claim contrary to long-standing understanding.
To Chile, do internal reports of battle of independent verification.
Your Honor, many of the reports are internal state documents. They form part of a consistent administrative, if not maintained from colonial to post-independence periods. Thus, reports are corroborated by maritime laws, customary exclusion, and governmental behaved privacy in the island. Together, they present a coherent body of evidence supporting continuous authority.
To Gabon, how does the applicant interpret the 1900 Franco-Spanish Treaty differently from the defendant?
Your Honor, Gabon interprets the treaty geographical description as aligning more closely with regional maritime division rather than strict cartography points. The treaty lacks precise coordinates, leaving room for interpretation regarding small offshore of the features. Gabon argues that when interpreted in good faith, the treaty supports of a maritime boundary replacement that favor its position.
To Guinea, was the defendant really solely on colonial documents on its claim?
No, Your Honor. The colonial documents form the foundation of
our legal title. Our claim is further strengthened by consistent administrative implementation, maritime enforcement, and diplomatic communication. These post-colonial actions confirm the continued exercise of sovereignty.
To the law, can you present any evidence of actual Japanese presence on land?
Your Honor, the police does not protest reports of permanent land presence, largely because the island lack habitation and or infrastructure. However, the plaintiff highlights long-standing maritime usage and regional recognition, which the context of uninhabited island provide meaningful evidence of effective authority. This pattern of use should be given due weight.
To Guinea, did Equatorial Guinea ever issue laws or regulations specifically addressing this island?
Yes, Your Honor. The islands appear within national maritime regulatory framework and administrative zoning inherited from Spain. This classification will require through the Spanish legislation concerning maritime boundaries and protected zones, demonstrating legal incorporation into our sovereign domain.
Okay, back to Kebun. If Kebun like land presence, what legal basis support your claim?
Your Honor, Kevin released on historical maritime practice, local tradition, and good faith interpretation of colonial boundary instrument. In dispute involving uninhabited futures, physical occupation is not the sole determining factor. The plaintiff maintains that consistent peaceful usage and proximity-based administration support is rightful claim.
To Ginny, how does the respondent justify a stronger claim despite both sides lacking permanent presence?
Your Honor, the start of our claim lies in legal title rather than physical occupation, Spain recognized sovereignty, transferred actions to Equatorial Guinea at independence, provides a clear legal condition, continuous administrative oversight of the court ensure that the title remain valid and uncontested.
To Gabon, does Gabon commit the authenticity of the Spanish colonial maps?
No, Your Honor. Gabon does not dispute their authenticity. Instead, we really question the interpretation of these maps, which were drawn with limited geospatial precision and often without regard to local maritime practices. The applicant agrees that such documents must be evaluated in light of regional context and treaty ambiguity.
To Jenny, were there any diplomatic exchange acknowledging your claim?
Yes, Your Honor. Historical communication between Spain and its body colonial administration consistently treated the island as foreign within Spanish jurisdiction. Following independence, Equatorial Guinea claimed that this position in several diplomatic contexts without receiving contradictory response from Gabon from the country.
Did Gabon ever seek joint management with Equatorial Guinea?
Your Honor, Gabon did not seek joint management because it maintained the position that the island fell naturally under its sovereign maritime space. Proposing joint administration would imply acknowledging a dispute, which Gabon did not consider necessary at the time. Instead, Gabon defeated its claim once the issue emerged formally.
Uji, is the defendant aware of any Gabon protests during colonial times?
Your Honor, there is no record of any Gabonese or French protest challenging Spanish authority over this island during the colonial period. Archival materials, including maritime charts, patrol reports, and diplomatic correspondence, show no indication of opposing claims. This long-standing absence of protest strongly supports the respondent's assertion of uncontested title.
The court thinks the member of the following bench for their question, and the expression to both parties about a clear and respectful response. The court is satisfied that the issues during the case have been actually addressed and that the further clarification is afforded at the time. This concluded just little question which the court will proceed to the next stage of the hearing, namely the closing statements from the parties. Counsel for the plaintiff will speak first, followed by counsel for the defendant. The court invites the plaintiff to prepare for its closing remarks.
Your Honor, distinguished member of the court, Gabon submits that the island in question, though uninhabited, lie within Gabon's maritime sphere and have been historically used by Gabonese fishermen. We acknowledge the complexity of colonial era documents, but we respectfully maintain that such documents require careful interpretation, especially where their geographical descriptions are ambiguous. The applicant further submits that the absence of permanent presence should not be the sole measure of the sovereignty, particularly for small uninhabited islands. Gabon has acted consistently and peacefully regarding the maritime areas surrounding the islands. For this reason, the applicant respectfully requests that the court recognize Gabon's sovereignty. Thank you, Our Honor, member of the court.
Your Honor and members of the court, Equatorial Guinea requests that if crime is grounded on solid and unitary legal title, the 1999 Franco-Spanish Treaty drafted white places geographic term explicitly placed that island under Spanish administration. That title was transferred lawfully and no case to Equatorial Guinea before independence. The respondent has demonstrated consistent administration practice, maritime patrol, regulatory inclusion, and diplomatic exception over many years. Gabon has not shown evidence of effective occupation nor any formal protect during the relevant historical periods. Therefore, we respectfully request the court to affirm Equatorial Guinea sovereign as supported by the treaty law and state practice. Thank you, Your Honor.
The court will now deliver its judgment. This case concerns the sovereignty over the small, inhabited maritime island located between the coast of Gabon and Equatorial Guinea. The plaintiff, Gabon, based in a claim primarily on historical maritime disease and separation of colonial era boundaries. The defendant, Equatorial Guinea, rely on the 1990 Franco-Spanish Treaty and subsequent administrative practice. Having examined the written and the oral submission, the court concludes that the respondent has established a strong legal title. The 1990 Franco-Spanish Treaty clearly authorized the island to Spain, and this title was transferred to Equatorial Guinea upon independence. The court also observed that Gabon has not demonstrated any effective occupation nor provide evidence of formal protest during the relevant periods. The court expressed its expression to both parties for their exploration and their precedent before the court.
Alright, the International Court of Justice has now concluded its sitting in the matter. The judge will be retired from the court. You might now be seated. The bench is excited, and today's sitting of the International Court of Justice is formally adjourned. The court takes all representative, witness, and participation for the cooperation to this proceeding. This concludes the hearing. The courtroom is now closed.